smart technology. Also, don't forget that it has a 3-year warranty, so it was a brand new car.
Wow, this is a great deal. It's better than others.
Yeah, all I say it was include and guarantees. What you see right now is exactly what you will get.
To be able to ship it directly to my house?
Yes, if you pay right now, I'm going to deliver it soon.
Great, then I'll pay right now.
Sure,
Thank you, you just made my dream come true.
no problem.
Finally, my new car arrived. Wow. Wait a minute. This is the car that I paid for? There's scratches everywhere. The touchscreen isn't even working. And the engine is making weird noises. And where's my warranty booklet? What the hell? This is not what I paid for.
Who the heck is this? Hello, this is dealership. How may I help?
Give me my money back.
Excuse me, who is this?
I'm the guy who bought your Mazda 3.
Oh, and is there any problem?
It's not the car that I bought, and it looks like a used car.
Sorry to hear that. We just ran out of stock suddenly. But is there any warranty booklet in the car?
No?
Then I'm so sorry. We can't help you since you don't have any warranty booklet.
You never gave me one in the first place, and now you're glazing me. I'll sue you. I'll see you in court.
Okay, fine.
Hello, I'm Ozzy. I'm Lukman. This is North States. Good afternoon, Mr. Ozzy. So you mentioned something about your car issue.
Yes, well, this seller lied to me. I bought a brand new Mazda 3. It was supposed to be brand new with a turbo engine, a wireless display, fabric seats, and 3-year warranty. But what I got instead was a scratched body, a faulty display, weird engine sounds, and no warranty booklet.
I see. So from what you have sent me, this is a clear case of breach of contract under the sale of goods at 1957.
So can I really sue?
Let me break it down. Okay, so Mr. Ozzy, under section 14A of the SOGA 1957 Act, goods must match the description. Your Mazda was clearly not as described. Next, in section 14 subsection B says goods must be of merchantable quality. A car with defects and scratches doesn't qualify. In fact, in the case of Grant against Australian Knitting Mills, the court ruled that goods must be in a saleable condition. And section 16 also provide that goods must be fit for their intended purpose. You bought a working car, not a repair project. On top of that, the Contract Act 1950 strengthens your position. Section 10 states that agreements enforceable by law are contracts, and this one is. Then, under Section 40, if one party refuses to perform their promise, the other party has the right to rescind the contract. Lastly, in Section 76 entitles you to compensation for any losses or damages caused by a breach. Then, in Bumi Armada against Star Cruises case, the court awarded damages when a party failed to meet contract specifications, which mirrors how the car you received doesn't match the promised features.
Well, that's exactly what I thought.
Not just that, Mr. Ozzy. You can also sue them under the Consumer Protection Act 1999. In Section 19 of this Act, it says that products sold must be free from defects. Also in Section 32 of the Act, stated that makes it an offence to supply unsafe goods. And Section 69 gives you the right to claim compensation for any losses or damages from those unsafe goods.
But they said the car was brand new and imported. I trusted them.
Well, that's another legal angle. In a case called Hadley-Barn against Heller, it stated that a seller can be held liable if a buyer relies on false statements when making a purchase. Since you clearly relied on their representations, it strengthens your case.
So what can I do now?
What you can do is you can file a claim for rescission, which means you can cancel the contract and get your money back. The next way is replacement, where for a car that matches the agreed terms. And then the third way is damages, which is to recover any losses or inconvenience that you suffered. So you'll be compensated with money. Or even specific performance if you still want the exact car that they promised.
Perfect. Let's hit them hard. I want
Sure.
justice.
We'll send you the papers later. Thank you, Mr.
Good afternoon, Miss Ria.
Hi, Vika. Please take a seat. I received your message, and could you tell me about everything that happened so far?
So basically, I sold a Mazda 3 to a customer named Ozzy. He agreed to buy it after I showed him a display model. But by the time I processed to order, we ran out of the stock. So I delivered a similar car, but I thought it wasn't a big deal. Right now, he is treating me to sue me.
Okay, Vika, I understand. Did the delivered car match the exact specification as you promised?
Not exactly. It has some scratch and the display doesn't work. I forgot to include the warranty book.
That is going to be a problem, Vika, because according to Sale of Goods Act 1957, the buyer has strong grounds. As you can see in 14A, you can see that goods must correspond to the description, such as promised as a brand new Mazda 3 with specific features and also delivered with a different one, which that's a breach. If you take a look at 14B, it also says that the car must be in a merchandisable quality, and scratches and a faulty display clearly violates them. Okay, if you look at section 16 as well, same from SOGA, it also says that if the buyer relied on your expertise or the description, the goods must fit the purpose. But right now, it does not fit the purpose, so they have grounds to sue you.
But I didn't mean it. I didn't want to deceive anyone. We just don't have any stock.
Intentional or not, when it comes to the Customer Protection Act, it still applies wherein, according to section 19, says that all goods must be safe and also free from defects, wherein your one is full of defects. And then the second one, which is section 32, also makes it as an offense to sell unsafe products. So when it comes to section 69, it also allows the consumer to claim for compensation for any loss or damages.
So what about their claim that I misrepresented the car?
Okay, Pika, right now if Ozzy did rely on your description and it turned out to be false, according to the case of Hadley versus Heller, you might be liable for negligent misinterpretation even without a written complaint.
So what do I need to do now?
After analyzing, you have two options. The first option would be to settle, whether you would like to offer a refund to them, or you could replace them with the car they initially wanted if you have available. So the second way is you could defend. In a way, argue with the buyer that the buyer initially inspected the car upon the delivery and accepted it, but with no warranty booklet and obvious defect, the defense is kind of very weak.
I guess the settlement is the right way.
I definitely agree, because it's better to negotiate than face a costly legal battle later, especially when you have a big defense. I'll prepare the settlement paper for you and contact the buyer's lawyer.
Let's be clear. Your client had promised my client a brand new Mazda 3 with top specifications. But what he received was a car with scratches, a faulty display, strange engine sounds, and no warranty. This is a breach of section 14 subsection A and section 14 subsection B of the Sale of Goods Act 1957.
We do admit that the delivery wasn't ideal, but I would like to confirm here that it wasn't intentional. The issue here happened due to the stock confusion, and still, my client here is willing to work out a solution.
I hear you, but under section 16, the car must be fit for its intended purpose. My client relied on your client's description and reassurances. That includes a working display, a clean engine, and a warranty. Under CPA 1999, it's unlawful to supply defective goods.
I trusted you, paid upfront, and I received a car that was clearly not brand new, and not a single person followed up, not until I called.
I'm truly sorry. I never mean to deceive you. I just desperate when there is no stock left, and I thought it can be fixed. But now it was my mistake. It was my fault. There is no excuse. I'm so sorry, Mrs.
Apologies are just a start. But my client, Mr. Ozzy, still deserves a full refund and reasonable compensation for the inconvenience, including transport costs and the time that he had lost.
We agree to refund, and we will work on a fair compensation amount for the damages we have caused, and also we from our side will provide a formal apology.
Again, I'm truly sorry, Mr. Ozzy. I hope this resolution can help rebuild our trust with each other, even if we can't change what actually happens.
Thank you. I just wanted what I was promised, and I hope you guys don't repeat the same mistake in the future.
In this whole situation, we saw what can go wrong when things are done.
law protects buyers under the Sales of Goods Act, Contracts Act, and also the Consumer Protection Act. On the flip side, PICA learned that even if the mistake wasn't on purpose, sellers still have a responsibility to deliver what they promised or face the consequences. Thankfully, both sides choose to talk things out, and with the right legal knowledge, they reached a fair solution.
So, the moral of the story, whether you're buying your dream car or selling it, honesty, clear communication, and a little legal awareness goes a long way. And always double check the specs before making a deal.